Thank you, Laska Hirlik. I'm sharing time with Senator Marie Sherlock with the permission of the House. This commencement matter is in the name of all the Labour senators, Senators Hoey, Sherlock, Moynihan, Wall and myself. And I welcome you to the House, Minister. Thank you for taking this issue. This is a very important issue. As we know, in late November, Minister Darragh O'Brien announced an eagerly awaited ban on this kind of accommodation, that is the development of co-living schemes. This announcement by him was widely welcomed by all of us. He was quoted as having told of his concern at the volume of co-living developments in the pipeline, their potential to put upward pressure on land prices and indeed the standard of living involved. However, UCD's Orla Hegarty has estimated that between developments already approved and those currently seeking permission, there may be 3,000 co-living units in Dublin City by the time the ban is actually implemented. So we are simply calling on the Minister now to implement the ban with immediate effect, even in the respect of those where construction has not yet commenced, or in particular, I should say, where construction has not yet commenced. I speak in particular in relation to my own area in Dublin Bay South, where 2 co-living applications are currently making the news, one on Merrion Road and one in Donnybrook in Dublin 4, the 2 of which are live. Submissions to An Bord Pleanála are going in, but in respect of both of which there have been quite a number of objections, 115 objections to the Donnybrook Road development and real concerns about standards of living. Indeed, the Donnybrook Road, or Kylie's Pub development, as it's more usually known, in respect of that one, the Dublin City Council Planner's own report expressed serious concern over the bedroom size. Notwithstanding that, we've seen permission granted by the Council on 19th January for 91 co-living units, what we might now call bedsits, but with communal kitchens and shared facilities, really not appropriate in the pandemic, not appropriate to create sustainable communities and not appropriate given the small size of the bedrooms. I'll hand over to my colleague, Senator Sherlock, now.
Minister, thank you for coming to the House today and taking our commencement matter, but I have to say to you that what was announced or what was implemented on December 23rd was not a ban on co-living in this city or indeed in the country. It's not a ban for the communities that I live amongst, that I represent, and there are 2 specific reasons for that. First, the failure to retrospectively apply that ban, and let me tell you what that means for the communities that I live amongst in Phibsborough, in Stoneybatter, in Dublin's north inner city, that over the next 12 months 1,096 co-living beds may get planning permission to be built within 1.6 kilometres of a radius of each other. Now that is an incredibly small area for such a large number of co-living units. And what makes this all the worse is that your department sat on a report from September and waited until November for the ban to be announced, and for December to actually give it effect. And of course, the great irony of all this is that the government, your government, made a song and dance about retrospectively applying income tax to PUP payment recipients last year, but yet there's a failure to retrospectively apply a ban on co-living to the developments already in the planning system. The second key failure, or the second key reason why this is not a ban, is because it allows a large exemption, which is if there is a proven need for this type of accommodation, then it shall be permitted. And Minister, the reality is the social housing waiting list in Dublin City Council at the moment, 55% of those on the waiting list are are individuals, single persons. So it's not beyond the bounds of probability that co-living at some stage would be deemed appropriate for these individuals, because such is the scale of the housing crisis in this city. And the last thing I want to say, and to make a particular appeal for your government to revise this ban, and failure to do so, I think, will cast a real question over your government's commitment to sustainable housing for our communities in Dublin and across the country.
Thank you, Senator Sherlock. We have 4 minutes now, Minister. Thank you.
Thank you. Thank you, Laska Hirlik, and I wish to thank Senator Moynihan and Senator Batchik for giving me the opportunity to address this matter in the House. On being appointed Minister for Housing, Local Government and Heritage, Minister O'Brien undertook a review of co-living development. This work was prioritised amongst many other important matters. Further to that review, it was indicated in a letter dated the 23rd of November 2020 to all local authorities, An Bord Pleanála and the Office of the Planning Regulator, that the preferred approach was to restrict the future development of commercial co-living development in Ireland. on completion of the necessary environmental assessment processes in the minimum time possible to ensure compliance with EU directive regulations, Minister O'Brien issued a subsequent letter to the planning authorities on the 23rd of December 2020, giving notice to the updated Sustainable Urban Housing Design Standards for New Apartments Guidelines for Planning Authorities, December 2020, had been published as ministerial guidance under Section 28 of the Planning and Development Act 2000 as amended. The main purpose of issuing the updated apartment guidelines was to give effect to the conclusion of the co-living review process and to introduce a specific planning policy requirement for a presumption against the granting of planning permission for co-living development. The reasons informing the decision included the inappropriate scale and location of co-living developments permitted and proposed at the time of the review. The need for local authority-led evidence-based approach to guide the provision of this type of accommodation, which may be informed by the housing need and demand assessment process, which is being developed within the local government sector. Potential impact on land values if the number of proposals at the time of review were to continue to increase in the current housing market conditions. New government policy and priorities as set out in the new programme for government, Our Shared Future, with a strong emphasis on expanded social and affordable rental housing sectors. The fact that at the time of the review there was a sufficient quantum of co-living units either permitted or subject to planning consideration to prove the co-living concept. Accordingly, specific planning policy requirement 9 of the updated guidelines was published in December 2020, provides that there will be a presumption against granting planning permission for shared accommodation co-living development unless the proposed development is either 1. Required to meet specific demand identified by a local planning authority under the Housing Need and Development Assessment process, or 2. On the date of the publication of these updated guidelines, a valid planning application to a planning authority, appeal to Bord Pleanála, or a strategic housing development planning application to Bord Pleanála, in which case the application or appeal may be determined on its merits. As such, SPPR 9 includes a provision to preclude consideration of new proposals for co-living development and was a proportionate, measured and swift response in accordance with the Minister's powers under the Planning and Development Act. The crucial point is that the Planning and Development Act 2000 includes explicit provision under Section 30 of the Act to ensure the Minister shall not exercise any power or control in relation to any particular case within a planning authority of the Board it is or may be concerned, notwithstanding under Section 28 in relation to guidelines. This is to protect the independence and integrity of the planning system. It was not therefore within the powers of the Minister or the Government under the Planning Act to simply ban the construction of co-living schemes in cases where applicants had already entered the planning process prior to issuing the updated guidelines. Furthermore, it is not within the powers of the Minister or the Government under the Planning Act to simply ban construction of co-living schemes where construction has not commenced and there is a valid planning permission in place. Planning permission is granted in accordance with the policy and legislation then in place at the time of the decision. A policy change after permission has been granted does not affect the legitimacy of that permission. Where planning permission is already has been granted for a particular development, such as shared accommodation, the applicant generally has 5 years to implement that permission. It is noted, however, that there is a provision in the Planning and Development Act to revoke or modify a permission under Section 44 of that Act, but this is not a ministerial function, rather a function of the Planning Authority. Thank you.
Minister Burke, would you like to respond to Senator Batchick?
And thank you, Minister, for setting out the legal position. And of course, we all respect the independence and integrity of the planning process. However, as my colleague Senator Sherlock has said, unfortunately, the net effect is that the Minister's announced ban really doesn't amount to a ban. And certainly in communities across Dublin, as Senator Sherlock and I have outlined, there is immense dissatisfaction and discontent about the manner in which these applications continue to be live and the manner in which permission has been granted subsequent to the announcement of the ban, because applications were made before the Minister's announcement on 23rd December. And we've heard just how many schemes, therefore, are going to proceed despite construction not having commenced, despite permission not having been granted prior to 23rd December. And that's the real concern. And we all know why. Clearly, co-living schemes maximise profits for developers. Co-living schemes are not subject to the same minimum standard as other types of residential development, and they raise serious concerns about their potential to create sustainable communities. We all know the huge need for housing and housing construction, but co-living schemes are not the way to build sustainable communities across Dublin. Thank you, Minister.
Thank you, Senator Batchik. You now have 1 minute, Minister.
I thank both senators for giving us the opportunity to clarify the matter, and within 6 months of coming into office, the Minister has acted within the full powers that are available to him. I think this is key here. The law is the law. The planning authorities, the law is very robust. I think the Minister has acted as best he can under the powers available to him, but also having regard to the integrity of Bord Pleanála and the planning system. And obviously, retrospective treatment of our planning law isn't appropriate, and it's very different than revenue law. Planning laws